Good afternoon, everyone. I'm Paola Bergamin, partner at Belluzzi International Partner. And with the help of colleagues in the next 60 minutes, we are going to address the topic of relocation in Italy of private clients and the impact this has in terms of estate planning. As you already know, a few years ago, the Italian government introduced preferential tax regimes in order to incentivize the permanent entry in our country of workers, wealthy people, and retirees. At Belluzzi, we have an international team of experts dedicated to assisting clients in relocating to Italy by obtaining the application of one of these preferential tax regime, as well as the consequent reorganization of the client assets from a tax and legal point of view. Before we start, I would like to point out that if you have any question, you can write them in the chat. And at the end of all the speeches, we are going to have a Q&A session. Okay, let's start with our first speaker, Luca Luone, from our office in Switzerland. Luca is going to speak us about the theme of relocation from a global point of view. As you already know, this preferential tax regime has been introduced not only in Italy, but also in other countries. Luca, which are the opportunities in Europe?
So thank you, Paola. Good evening to everybody, and thank you for attending this webinar tonight, which intends this webinar to give you an overview of the current instruments that the Italian law provides in relation to the migration of international wealthy people who are aiming to find, in our opinion, a suitable environment for their life and prosperity. The argument that I've been assigned, as correctly Paola said, intends to give you a quick analysis of the other European countries' opportunities that we can say that, if compared to what Italy has been offering nowadays, confirms the competitiveness of the Italian current scenario. First of all, it should be remarked that not only that the lump sum taxation provided by the Italian special tax regime on foreign incomes that would be extended to the applicant's relatives, but also the non-applicability of the inheritance and donation tax on the assets as held abroad, as we may better see during the following speech of my colleague. This is a great opportunity for the reorganization of wealthy people assets in view, for instance, of a generational shift, or simply for meeting the needs of a complex family. Furthermore, you may further appreciate that in Italy, Italy is one of the most important countries in the world in terms of culture, works of art, food, natural beauties, and all these features makes the Italian tax offer even more attractive. So we can now take a quick glance to the specific offers of the other European countries, which have introduced in their own legal context similar tax incentives for wealthy people who intend to move from their current country of residence, and that are growing more and more every year, as we have seen in the previous slide that has been shown. In particular, I would spend a couple of words about Switzerland, because the special tax regime provided by Switzerland is completely different from the other ones provided by the other European countries, because the tax basis is calculated not on the income earned, but on the actual living expenses in the country. And we have also to say that this special tax regime, even if in the past was one of the most known and the most appreciated, it's been losing its own attractivity in the last years because the minimum federal tax basis has been increased to 400,000 Swiss francs per year, and above all, the state tax has been included into the calculation. So this would mean that Switzerland is really interesting from a certain point of view for a certain taxpayer, but it's not so interesting as it was in the past. I would also spend a couple of words about Portugal, because Portugal, as you all are aware, provided with a special tax regime in the past that was very, very interesting, and this special tax regime unfortunately will end for Portugal, of course, unfortunately, will end from January 2024. And this will mean that a strategical competitor of the other European countries will be simply out of the game of the relocation. And the same thing, because this is one of the questions that we are often required to reply. The same situation, in our opinion, won't happen in Italy because the special tax regime enjoys, first of all, the support of the politics in Italy, but it has granted relevant direct and not direct income to Italy. And furthermore, if it would be deleted, the government would need to find new taxes. And in the current scenario, in the current context, this would be really a bad thing for the Italian government. We are obviously supporters. We can see the different situation, the different offers of the other countries in Europe. For instance, Greece is quite similar to the Italian one, tax special regime. But we are obviously supporters of the Italian proposal. But we are also aware that any decision depends on the actual needs and the personal situation of every single person who decides to move abroad, not only for seeking the best or the cheapest tax offer, but also for finding a general quality of life. And this is the reason why we are sure that Italy, because all of these features, could be a good opportunity. And our firm is able to provide our clients with the most accurate and careful assistance in all these European countries we talked about before. Thinking to a direct presence in certain territory, like in the United Kingdom, in Italy, or in Switzerland, or thanking through the professional network composed by the most important firms and professionals that are involved in the migration process for wealthy people. So I hope you enjoy my introduction, and I leave my colleague to go ahead, but I remain at your disposal for further info or questions at the end. Thank you.
Thank you, Luca. Let's move to Giacomo Francioni in our office in London. Giacomo, what about investor visa and other tools to enter in Italy for people that have not a EU passport?
Yes, thank you, Paola. Starting from the short-term visitors, The nationals from the Schengen area, from EU or EA or from Switzerland, can travel to Italy without a visa. Short-term visas under Italian law allow the non-EU holder to spend up to 90 days in Italy and within the Schengen area. Depending on the country of origin, certain non-EU foreign individuals can freely travel to Italy with simply a passport of identification. And in that case, their stay within the Schengen area cannot exceed 90 days in any 180-day period. Third country nationals can apply for short-term visas in the country of residence through the Italian embassy or consulate. Instead, looking at the investor visas and permit, this type of visa represents a special category of a national visa for foreigners wishing to invest in the Italian market. The investor visa provides for a 2-year special visa and resident permit. The visa is renewable for another 3 years by applying at least 60 days before it expires. There is no maximum number of renewals. And in order to claim the investor visa, the individual is required to make one of the following investments. At least 2 million euro in Italian government bonds, or at least 500,000 euro in Italian companies, or at least 250,000 euro in the share capital of an innovative startup company, or to donate 1 million euro to philanthropic projects. And from the 2020, the investor resident permit holder is not subject to a minimum period of stay. And it should be noted that the visa does not cover the other family members apart from the applicant. Looking at the other visas available, the foreign nationals wishing to relocate to Italy and having a financial capacity to live without working can apply for the elective residency visa. And this category of visa is mostly suitable for those who wish to retire in our country. And it's perfect combination with the pension holders special tax regime. In order to obtain the visa, the foreigner should mainly prove to have sufficient financial resources to support himself without working, and has a maximum validity of 1 year, renewable without any limitation. And foreign nationals having a valid resident permit are eligible to apply for this family visa, so-called family reunification visa, with regards to their family members. And the special visa allows the holder to join the family member that are already in Italy. For the working visa is, let's say that the national visa is not required for EU, EEA, and Swiss nationals to work in Italy. Instead, non-EU foreign nationals wishing to work in Italy need a national visa. It's called Visa D, even if they intend to remain in Italy less than 90 days. Within 8 days of entering Italy, the foreigners must apply for a resident permit. And before applying for the procedure, however, the non-EU foreigners must check whether the entry quota limits for foreign workers are still available. Certain categories of workers are exempted from these limits, such as, for example, university lecturers. Additionally, under the requirements provided by the EU Blue Card Directive, companies can hire in Italy executives and high-skilled workers without considering the entry quota limits. The procedure for non-EU employees requires the involvement of the Italian employer, who will be in charge of the application first, and for the work authorization at the immigration office. Such a procedure can take up to 3 months, and once the authorization is received, the employee can apply for the national visa and then enter Italy. For self-employed workers, Italian law provides for 3 different categories of visa. The startup visa for foreigners wishing to set up an innovative company in Italy, a freelancer visa for foreigner wishing to take up self-employed activities, director or auditor visa for foreigners joining an already existing company as executive. But all these visas should follow the requirements of the entry quota limits. A quick mentioning should be made for the British citizens after Brexit, because in accordance with the provision of the EU regulation, British citizens do not, willing to travel to Italy, of course, do not need a short-term visa to spend up to 90 days within a period of 180 days. Instead, it's the national visa is required for a long-term staying. And a specific difference is for the UK citizens in Italy before the activation of Brexit, so the 31st of December 2020. For these citizens, Italy guarantees the right of free movement exercised before Brexit. It's again important and strongly advisable to request new residence documents with which UK citizens can easily prove to benefit from these special provisions. Thank you. Thank you very much.
Thank you, Giacomo. Now we listen to Domenico Sanicandro. Domenico is the head of our relocation team in Italy, and he is going to speak about the Italian flat tax regime, and in particular, thanks to our experience in advising our clients in the application of these regimes, he will explain to us what to do or not to do in order to obtain the application of the regimes in Italy.
Thank you, Paola, for your kind introduction, and of course, thank all of you for attending our webinar today, sharing your time with us. The new tax residence regime is probably the most important, a very well-known regime applicable in Italy for people willing to move to our country. The regime allows to the applicant to pay a near amount of 100,000 euros as a subsidy tax in order to covering all foreign income and capital gains. In general, the regime and the application of the lump sum taxation cover also the inheritance tax, the gift tax, wealth taxes, and for all rights and assets held abroad. This is very important also, right? We can see later for privacy reasons, because the applicant has not to declare in the tax return the FW form, in which, as usual, you have to declare all your foreign asset. Of course, it's an option. It's a regime applicable to an option, and it's applicable for a maximum of 5 years. Of course, in case of opt-out, you cannot rejoin the regime, and you can opt out when you prefer. From practical point of view, we can say that the regime has been introduced in the 2017, and of course has been commented by the tax authorities in the circular letter number 17 issued on May 2017. Through the circular letter, we can see that the tax authority position is very pragmatic and confirms all the positive environment that we can see in the regime. The regime is open to all individuals, also to Italian citizens that are willing to coming back in our country, and of course needs that this individual, this person, moving their tax residence to Italy according with our domestic rules, in particular with Article number 2 of the ICTA, the so-called TUIR. And another point is that this transfer of the resident must be effective, because there are some checks carried out by the municipalities. The only requirement that the individual must be met is that the famous rule, the 9 out of 10 rule. So individual must have not been resident in Italy in the last 9 out of 10 years prior to the first year of elect the fact, the option. Of course, the application of the regime that, repeat, is by option is through 2 different ways. The first is through the applicable through the ruling to the tax authorities, in which, in a nutshell, we assist our client in asking to the tax authorities if the requirements provided by the law are met, or directly to the tax return. To be honest, all our clients opted for the ruling part, because, of course, the ruling part is the only way to receive a formal written answer by the tax authorities. So this is the only way to see the formal approval of the tax authorities to apply for the regime. The lump sum taxation covers, as repeated, for all foreign income, so the foreign source income and capital gains. The application is made by the first applicant paying €100,000, but is to be extended also to each other member of the family. In this other case, the member of each member of the family has to pay only €25,000 for each year. Of course, there is a particular anti-abuse rules that exclude for the new regime only the capital gain realized on foreign qualified participation during the first year of the new regime. The new regime is in full compliance with the CRS program and in general with the ML compliance international rules, and of course is very well recognized by the all tax treaty signed by Italy. Another important point is that, as stated in the circular letter 17, that CFC rules are generally not applicable to the individual, and it is possible for the applicant to exclude certain countries from the new regime, the so-called cherry-picking clause, that implies that the income deriving therefrom will be subject to the ordinary taxation rules. Of course, all income arising from our country, from Italy, will be treated as ordinary regime, and they have to pay ordinary taxation as normal residents. Very, very important point to underline, that is a very important characteristic of the regime, that there are not remittance concepts. The applicant have no problems on transferring foreign income or asset to Italy without paying any taxes. Moving to the application, the practical operation of the ruling, we have to say that the answer of the tax authorities in general needs to a period of 120 days. And in our practice, we used, before starting with the ruling, we start to an assessment phase in which we check if the applicant met all the requirements provided the state by the law. Another point that is very useful for the applicant is that on March 2017, the tax authority publishes the so-called checklist in which the country must fulfill to access to the regime. Very simple questions, yes or no, kick the box. And this is a very pragmatic and soft approach to avoid abuses directly from the tax authorities. Another important point to underline here is that there is no need to modify the international estate planning, for example, for international clients, because it's, of course, because the regime allows to the applicant to cover all assets and rights held abroad, so granting full privacy and, of course, granting the compliance with all international rules. Of course, it's very different from for example, the Swiss global regime or other quite similar regime, but probably in Europe is the most simple, easy regime to apply. Of course, it's the regime is in full compliance with all tax treaties signed by Italy, and in its compliance with the main rules. If I have another minutes for discussing a few practical cases, Paola, sorry, because, for example, the regime apply very well with also the investor visa, because, for example, individual non-EU passport holder can apply for the investor visa, and then for entering in Italy with the valid resident permit and visa too, and then apply for the new tax resident regime. For example, we assist a lot of clients from Israel, Brazil, in the last years from UK due to the Brexit, of course, in this case, all assets held abroad, in this case, this individual was a UK resident dom, as the only tax that this person has to pay is the lump sum taxation, so the 100,000 euros for year for the 15 years. This is very important because the tax return has only to complete in two forms, and you have to avoid to declare all your assets abroad. And the second case that I've already anticipated before is regarding the well combination with the investor visa, because is let me say a perfect path to entering in Italy and with a very good tax planning in full compliance, of course, with not only the Italian rules but European rules. In this case, we assist a family from Turkey. They have a lot of asset abroad, and they opt also to invest in Italy. Of course, all investment in Italy will be taxed as ordinary with the ordinary regime. All the assets settled abroad are covered by the lump sum. Hoping that I stay in my time. Sorry if I going outside my. Sorry.
Thank you very much, Domenico. Luigi Belluzzo, as I've already said during my introduction, when we assist a client to move to Italy, we also must be attention about estate planning. What can we say about the international trust structuring for a client that decided to relocate in Italy or in another country?
Good evening, everybody. The main concept here is that we are, because I'm following also some queries from the audience, we are discussing only about the new tax, Italian tax res and its implications on international trust and estate planning. And actually we will have a room to debate later, but certainly the Italian new NTR, like we call it, it's one of the few who comply very, very well with international trust and estate planning, because it has been in a way designed to do so, but also because Italy knows very well trust since more than 30 years. Italy signed the Hague Convention, and Italy received last year in October, almost 1 year ago, 60 pages of useful guidelines on what about the interpretation of the tax authorities of direct and indirect taxation of trust. So my speech today is going to be concentrate only on some examples, just to give you further room and thinking about the quality of this regime, which, as Luca said, is not the only one, is a very good tool anyway for global families. And because of that, if I can, yes, that I have prepared 4 slides with 4 cases. This is the all real cases. Perhaps Domenico, we didn't stress the fact that Italy NTR regime did not work for the first 5 years capital gains according to Italian tax rules. This is because the Italian legislature decided to comply fully with EU guidelines, and our regime, the NTR regime, I mean, it's a regime which is not harmful, the European competition. So in this case, Mr. X, high net worth individual UK resident, already owning a company, in this case, it was not 100%, but a stock listed majority, he sold it and he made quite a good capital gain, of course, optimized by UK tax lawyers. And actually, he has this cash and investment portfolio in Guernsey and in UK, because the bank presented as the case was an English bank. And before the transfer, it's quite important and relevant to think about the route, because it's English dweller and English citizen, English passport is not EU. So we have to have the investor visa to Italy. And the investor visa must precede the entrance with the NTR, because otherwise you cannot overtake the tourist visa. It means that we started, just to give you an example, 6 months before his immigration to Italy. It is very important and bureaucratic, the process. You need to provide some information. We have, of course, a list. And once we start the procedure, then you make your commitment to make the investment. As Giacomo explained, you have the 2 + 3 years and so on. Be careful, it is not the Italian passport, it is a Schengen visa. Then, because of that, he made application of the new tax resident ruling, and through the ruling, he has basically, all know, he only owned a house in Umbria for 3 years, but it was very clear by the utility bills that it was a holiday house, and the Italian tax authority do check this. They do check cars, they do check utility bills. So it's quite interesting, and we have experience because we have made many of these cases. And the last but not least step is a change of residence. So once he has the investor visa and once we had the ruling, he moved himself and the family, and actually all his earning in Guernsey and abroad was not and are not taxable because he already pays 100,000 K. The example is important because Italy recognized Mr. X as a UK tax resident, and of course it's providing application of the dual tax treaties. There are some resistance from some countries, which we may discuss later in Q&A. My second example is a sophistication using trust, so I can answer Paola, because the Italian new tax resident applicant can do a trust, in this case a Jersey law regulated trust with funds in Monaco, in Switzerland, and real estate and financial assets, and a direct portfolio in Guernsey again. After the transfer, he can set up a trust, and this trust can have retained powers. As far as in Jersey, according to the law, we are not going toward the sham, so it is a legally valid trust. According to Italian tax rules, because it's an NTR payer, 100,000 K per year, he is, of course, in a very useful situation where he can mix the global structure of his wealth through trust. We will see also with Valerio later on that this makes also a different regime for exchange of information. So the use of trust and relocation in Italy, the use of literally international, non-commercial, discretionary, opaque trust according to Italian tax rules and the NTR are quite efficient. We can provide further information later on. My third case is more related to a guy from the private equity industry. He wanted to relocate with his family and children, so he paid 125,000 K because 100,000 for the main applicant, 25 for the wife, and he is very important wealth is he carried interest through a share structuring. And again, we have experience on dealing with the tax authorities in order to provide the NTR, the new tax resident, with the fact that the PE income and capital gain will be absolved according to Italian tax rules within the 100,000 K. And of course, in this specific client, he decided to set up a trust. And this is not an Italian, is not an English citizen, and he decided to make an international discretionary trust to put his non-Italian assets, and he can enjoy, of course, the benefit of international trust and estate planning with the NTR. My last consideration, Paola, also to stay in my given time, is basically, if I can change, it doesn't move, it doesn't move, sorry. It is basically my last case. It is relevant because you asked me also about trust. And I say, well, trust without relocation could be a very good alternative on people from abroad who wanted to invest in real estate in central Milan or in central Rome or in Tuscany or in Venice or wherever you want in the beautiful Italy. And because of the new rules, according to the guidance gave to the circular newsletter from the tax authority through the circular newsletter 34E, a good alternative is to set up an Italian trust, a tax resident trust regulated fiscally in Italy, of course, with the foreign rules, so the Hague Convention is applicable. So the client decides his own rules, for example, an English law can apply, and the trust is basically working like a private individual in Italy. So he owns a home in Italy, a house in Italy, and after 5 years, any potential capital gain are tax-free because of our domestic rules, exactly like a private individual purchasing a real estate for his proper benefit in Italy. So I believe that in a very quick, but I hope efficient way, I gave room to 4 different alternatives relating relocation and trust. I thank everybody, and I give my word to Paola. Back to Paola.
Thank you, Luigi. Let's finish with compliance. With our Valerio Vallefuoco, we are going to speak about the anti-money laundering law and the exchange of information, CIRS. So, Valerio, what can we say about this related to the topic of relocation?
So, good evening to everybody. I'm Valerio Vallefuoco. I'm the partner of Rome. And I want to explain you that we are specialized in assisting taxpayer in international tax cooperation, Italian, European, international anti-money laundering legislation and tax legislation. Usually we perform preventive audit for the application of the favorable tax regime. 2 good news. One is from European Union. Yesterday, the Council of Europe adopted DAC 8, Directive of Administrative Cooperation number 8, that was a sort of boost of cooperation between the national taxation authorities in a very, very quick summary. There are 2 subjects that they explain and they explore. One is crypto asset, a sort that DAC 8 is a sort of CARF, it's an automatic exchange of information between OXE for crypto asset. And the other, I think, is very interesting for our matters, is the wealthiest individuals, or high net worth individual. What is the news? The news is that now, from next year, will be mandatory in Europe, the automatic exchange between tax authorities information for crypto asset service providers. And also, there is next steps for the high net individuals, high net worth individuals, for to communicate every year the tax agreement, the tax ruling for these people, and also give the tax number, the TIN, tax identification number. This is a very interesting news that from the next days will be published in the official journal of the European Union. And we have not more time to follow this law, and all the Europe must be follow the law. From Italy, news from Italy. After 2 years, we apply definitely the UBO register. UBO register is, you know what is a UBO register. We are very slowly, but we are the best, I think, UBO register in the European Union, because we are the last, or quite last, but we apply the judgment of the Court of Justice, the European Court of Justice. So we defend the taxpayer, we defend the beneficial owner, and in our law, it's possible to not give data to everybody, but also only for the obliged people that before must register themselves and explain the matters and what they want to ask. There is the ability to oppose the treatment, and if the lawyers that assist you in the sending information to the UBO register, give his address, electronic address. In Italy, we have a specially certified email. The name is PEC, but this is a sort of very certified email with the law we use for the trial, for example. In that case, you can defend your client from from request that you can't believe are comparable with the law and with the privacy rule. So this is a very new, interesting area that we can give to all our clients. In other case, I can also explain that in Italy now we have a new system for the SAR that starts from the 2024, the 1st of January. We have some cases that our financial information unit give to everybody to simplify the way of thinking to do a SAR. So there is more materials. We have the availability to consult these materials before, and we have the possibility in our preventive audit to give you the right opinion and to give a compliant opinion about the tax operation and also the corporate operation, also for the transfer for destination Italy. This is our goal, and I think that will be very interesting also for give to the taxpayer of other nation, other country, that in Italy now we have many instruments to assist and to defend preventive and after a request that is not compliant to the GDPR or the European rights. Thank you very much indeed.
Valerio, Paola, if I may, as we can say, talking on new tax resident regimes, is that Italy clearly decide, I don't want to say the other countries not, but Italy clearly decide to have quality, compliant, ultra high net worth individuals. So the regime is quite strict, but for anti-R, it's of course relatively applicable because it is applicable to the goods they have in Italy. So if they open a bank account, it is however relevant to talk about exchange of information because of course Italy comply with CRS and with FATCA. And for new tax resident regime, perhaps I very briefly touched it in my example before. It is clear that if the anti-R applicant has a bank account in Switzerland, because of CRS, the Swiss bank will communicate to the Swiss authorities, the Swiss authority to Italy. Italian information will be gathered in a very safe box within the tax authority. We had also a case, and I want just to underline that, where privacy was quite relevant because of historical facts in the 70s. And we discussed with the tax authority and we agreed that through the trust, because of the way CRS works, not all information were arriving to Italy. We didn't give a full disclosure to them, but they were, of course, asking who was the people. So we explained exactly the reason behind. It was a very problem on terrorism in the 70s. And because of that, of course, it is possible, we learned that it is possible also to make a moderate arbitration about exchange of information. So we are not limiting, we're not doing dual passport, but we are just working on the fact that the trust, when the beneficiaries are still under non-vested and where the settler has a proper arrangement, because of CRS, the trustees are the name in the list, and this gives privacy. So, Paula, I just wanted to mention that. So it's up to you. I know that there are some questions and queries.
Let's finish with the Q&A session. We have received a lot of questions, but I'm afraid we have no time to answer to all of you. But let's start with a few questions. So the first one, can an adult child be included in the application for the Italian new tax resident regime? Domenico, can you answer to this?
Yes, Paula, yes, the regime can be extended to one or more qualifying family members. Now, each member may be admitted to pay an annual flat tax of 25 key euros in order for benefit for this regime. Note that the concept of family for these purposes is very broad, as referred to in Article 433 of the Italian Civil Code. Spouse, children, parents, son-in-law, daughters-in-law. Pay attention also to mother-in-law, let me say. So the principal difference by the regime between main applicant and these family members is only on the amount due as a subsidy tax. So the effects resulting from the access to the new Italian tax regime are, of course, the same for many applicants.
Okay, thank you very much. We have another question, which is this: a British lady with a visa for elective residence can access the new tax resident regime?
Yes, but we have to remember that with the elective resident regime doesn't allow to the applicant to work in Italy. So if this is the case, there are no problem to apply also for the new tax resident regime. Yes, of course.
Okay, thank you very much. Another question. As Lucas said in a speech, the Portuguese Prime Minister announced the end of preferential tax regime in 2024. What about the future of such regimes in Italy? Luigi, do you want to give your opinion about this?
Yes, well, funny enough, I was involved in Hungary at Step Europe conference. We had a panel with the Portuguese, the Spanish, the Israeli, and other colleagues talking of different regime. And the question was this one: what is the impact and why the Portuguese? And actually, our Portuguese colleague gave an answer which I share. It's a political issue. When they started to have their investor visa in Portugal 15 years ago, average, the price of houses in Lisboa was very low. Now they are very high, so the new government probably reached or met the aim of having this regime as a tool for. Of course, they had a real success on pensioner. Some rumors arrived that was the EU Commission and others. My reply to your query publicly before the news of a couple of days ago about Italy was that the new tax resident regime, it is designed in a way that according to our structure of public finance, in order to change NTR, the government or the parliament should find a different and alternative way of gathering money. And you know, we are talking about a small number because its official number are for last year is 1,200 plus, but we're talking about around 100 million euro, which is a drop in the ocean of Italy. But again, if they want to change, they need to find the money. So I don't think we will assist to a contamination of this in Italy, certainly not for the new tax regime. It's different for, as I said, for the impatriati regime that we are not touching today, the regime for talents, in which actually we have a very big news, because yesterday the few lucky one had the preview of the text, and the text of the new rule, which is still a draft related to the will of the government, but with the numbers in parliament, I have no doubt that we will see it, is to change and terminate the impatriati regime as we know, and to substitute it with a more sophisticated way, maybe simpler, having only 50% with a limit of 600,000 euro income, etc. We will have, of course, room to comment that. We will do other seminars. This is more on ultra high net worth individuals and estate planning, which I believe is not going to be affected, and certainly not for who is already in. And what I can say is that as a firm in London, in Switzerland, in Italy, and in Singapore, we are seeing a very important, relevant interest on the Italian new tax resident regime. And we are actually working with a lot of law firm, international banks, in order to allow the fulfillment of knowledge and started to have these new cases in Italy too, which is good for Italy.
Okay, thank you very much.
If it's possible, Paola, only two things. There is also in Italy an advanced legislation, both tax and anti-money laundering on crypto asset. There is the possibility to regularize, to revalue, to declare the value of the tax authority. So it will be able to freely exchange into fiat currency or on financial normal investment. In Italy, there is also at the end the possibility of combining the various value regime for all the crypto asset. In fact, recently our IRS has established that the possibility of obtain exemption from taxation for all crypto asset trading survival abroad for the people resident abroad. So the external taxpayer can combine the tax regime for 24 bis, 24 bis of our tax code, that they will have ability to have a total exemption from crypto asset they were trading before to change the residence.
Yeah, and actually, Domenico, you had some cases about that, no? And one was also quite complicated to explain to the tax authorities because of the jurisdiction involved, namely the US.
Yes.
Not a tax haven.
Yes, correct.
Okay, Paola.
It is 7 p.m., so our time is finished. So let's say thank you to all our speakers. Thank you to the attenders. I hope you find it interesting. We have recorded a video of this webinar, so it will be available in a few days, so you can see it again if you want. And if you need any advice, write to us, and we will be happy to answer to you. Thank you very much.
Thank you. Bye-bye.
Thank you. Bye-bye. Ciao.
Bye.
Thank you for everybody.
Thank you.